Community property. What do you do with community property? We're here in Texas, and we do get this question a lot. Do I recommend that all spouses be included as beneficial owners under the ownership test for the beneficial ownership reports? Yes. Again, what I'm looking at here, these are undivided interests. The ownership interest of a community property interest, it's owned by both spouses. It's basically both. I would not report it. So if they have a 50% interest, even if it's titled all in one spouse, I would treat it as 50% for both of them. So if you've got 25%, I would not say, oh, well, it's 25 for the husband, 25 total for the community, 12 and a half for the husband, 12 and a half for the wife. I would put them both down. Frankly, that's what I did with my law firm. I reported my wife entirely. We're in there. And again, it's because the rules refer to joint ownership with one or more persons of undivided interests. And if you've got these joint ownership interests, I think you put everybody together and that's where you are. Don't proportionately reduce it. I don't see a reason to do it. I haven't seen anything in the regulations that says you would want to proportionately reduce it just because it's community property. Now, if the interest is separate property, that's different. That belongs just to one spouse. It belongs just to one spouse. You're not going to get it out absent something else happening through a court or some sort of transfer of that interest. Finally, when it comes to substantial control, just because one spouse has substantial control over an entity, perhaps because they're a president of a company that is a reporting company, I wouldn't impute that by community property to the other spouse. Basically, if you have one spouse that has substantial control, community property is not going to apply to the other spouse.